seated.
Good morning, all. We're here for trial in the matter CFI-044-2021, Mr. Shiraz Mahmood versus Standard Chartered Bank DIFC, before Justice Wayne Martin. The claimant is represented by Charles Russell Speechlys. Lead counsel is James Bickford Smith. The defendants are represented by Adil Shah Goddard, Middle East. Lead counsel is Mr. Mohinder Pal-Safi KC.
Thank you. Well, there's no need to take appearances because they've been read onto the transcript. Mr. Bickford Smith.
Good morning, Your Honour. I propose to begin with housekeeping and bundle points and then proceed on to open the claimant's case by particular reference to the pleadings.
Yes, that would be very helpful.
On the bundle, the difficulties uploading materials are now resolved, and I'll just read in some references for Your Honour in terms of what's changed since the skeleton. So the skeleton argument for the claimant is at bundle page 7960.
Yes.
The claimant's reading list is at 7985. Claimant's chronology 7987. A list of acronyms, which I hope has reached you. It was a useful document, 8015. The defendant's skeleton is at 8019. The defendant's chronology is at 8048. And then the authorities. Now, these start at 8052. Now, I should say that at the moment, it's all in one bundle.
Yes.
And a thought that I had was that it might be useful for the court to have a separate authorities bundle, and that will be being sent. It's been sent to my learned friend. That has the court bundle number in one corner in red, and an internal numbering at the bottom, and it also has an index at the start.
Oh, good. Thank you. That will be very helpful, I'm sure.
One other bundle point, and this is in a sense a document I do not want you, Your Honour, to see, which is that a without prejudice document has slipped into the bundle. It is being removed. I have discussed this.
Don't tell me where it is.
I'm not going to tell you where it is. And there is an agreed timetable for trial.
Yes, I've seen that. Thank you.
So to begin with the pleaded case, at page 6 of the bundle, one sees the amended claim form. It's pleaded that there's been an unlawful termination in breach of Article 59.3 of the 2019 Employment Law, and then Article 62. So it's the termination of an unlawful act of victimization. The simple facts pausing there is that these claims necessarily will raise issues for legal submission because they are new territory for this court. Although this is not the first claim under the discrimination part, that's part 9 of the 2019 Employment Law to reach trial, the trial in the claim that was the first to trial settled during evidence. So we are, as it were, first up. Now there's a temptation in such circumstances to say this is all very difficult, there are lots of points of law here. But my submission and respectful suggestion is that the right way forward is just to deal with legal issues at the appropriate time and by reference to the facts as found by the court, rather than to consider the case as something equivalent to an exam paper. Pursuant to that, I'm not going to address remedy issues at all today because they're a classic matter for closing. The claimant has set out his stall at page 7 of his claim form, and then at the end of his amended particulars, pages 76 to 77, the defendant disagrees on the law as well as on the facts, and these should and will be matters for closing, so I leave that there. I did, however, say that I would be addressing the case by particular reference to the claimant's pleaded case today. I say that because my learned friend's skeleton argument shows that there is a dispute about what is and isn't pleaded in the case, and I refer especially to paragraph 14 of my learned friend's skeleton, which runs over 10 pages, or just under 10 pages, and part of the submissions advanced therein is that some matters that are in the list of issues are unpleaded or of background relevance only. And to be clear about this, that is not accepted by the claimant, nor are the complaints about the pleaded case in terms of how it is framed. those are not accepted at all. And a simple point I make at the outset is that this is a matter where the list of issues was agreed almost a year ago now, and where the pleadings went through a process of amendment at the end of 22, start of 23, and where there was, of course, as Your Honour will remember, a pre-trial review before you.
Yes.
And what we say really is that the defendant quite clearly knows the case it has to face and to meet. We have hundreds of pages of witness evidence in this matter, and it is, we say, not the right time now to be taking these kind of pleading points. But just to go through the amended particulars, I'm going to start with paragraph 7 of that document. So I'm going to start with paragraph 5. This is at page 11 of the bundle.
Good.
So one sees there the basic claims. Breach of Article 60. Those are the victimization provisions. Breach of Article 59. Less favourable treatment and detriment, including dismissal, on the grounds of his race and or nationality and or religion. Now, 2 points. First,
Sorry, and or religion's been struck out.
that was my first point.
Yes.
As Your Honour will see, and or religion has been deleted. Religion, I can confirm, is not a part of the claimant's pleaded case. But by the same token, this case has always, in fact, been pleaded, even prior to amendment, as both a race and nationality case. Then one has a claim under Article 40 of the old employment law, Article 43 of the new employment law. That relates to the working environment and the employer's duties with regards to that. It gives rise to discrete issues of law as to remedy, but it is not going to be the subject of sustained submissions by me here in opening. And then, against that background of a claim on grounds of race and or nationality, one sees that at paragraph 7, it's pleaded the claimant is of British nationality and Asian race, and then it's specified his father was born in India, his mother in Pakistan. He left Pakistan when approximately 6 months old, never lived in Pakistan nor held a Pakistani passport. He identifies himself as a British Asian, not as a Pakistani.
If it helps, Mr. Bixford-Smith, I can tell you that I've done all the reading. I've read all the pleadings. I've read the skeletons. I've read all the witness statements. I've read the chronologies and the documents referred to in the chronologies. So
I'm very grateful.
So I have a significant familiarity with the detail of the case, if that helps.
It does help because it saves time, and I'm grateful to Your Honour for the pre-reading. And what I'm going to do, therefore, is simply to go to the areas of where it's apparent there's a disagreement as to the scope of the pleaded case. In other words, what's submitted, particularly in paragraph 14 and elsewhere, of my learned friend's skeleton. So if I can just go to that document. Beginning at paragraph 7.2 of that document.
Page of the trial bundle.
I'm just getting it up to check that it hasn't changed. 8020.
8020.
No, it's going the wrong way. No. Hang on. 802. 802. No, I can't read it. 8024.
Yes.
It said that.
paragraph 14 of the skeleton, defendant's skeleton.
Sorry, no, this is paragraph 7.2 of the defendant's skeleton.
Right, thank you. Yes, I have it.
Just a couple of points, and this is by reference to the pleading, the passage of the pleading to which I have just taken, Your Honour. First, it's said at paragraph 7.2 of my learned friend's skeleton that born in Pakistan is of Pakistani national and ethnic origin. I'd point out that that isn't the defendant's pleaded case. Page 82 of the bundle paragraph 7. The second 3 lines down, the first sentence of paragraph 7 is admitted. No admissions are made as to the second sentence as to which the defendant has no knowledge. So there's no positive case there advanced of Pakistani national or ethnic origins. And while we're on this, I need to address a related point, which is suggestions here that there's a case being run on colour discrimination. Now, the simple position is that colour is not a protected characteristic under the 2019 employment law. Race and nationality are. What the claimant was doing in paragraph 7, to which I've just taken you on, was identifying his origins and his nationality. And when one turns to the pleading of a comparator, which is at comparators, there are 2 comparators pleaded. This is at page 73 of the bundle. So there's no issue as to the first comparator. Then it said at the bottom, the claimant's case is that the appropriate hypothetical comparator would be a Caucasian person with white skin. That doesn't mean that he is claiming colour discrimination. It means that he is relying on a Caucasian comparator. So it's simply wrong to say that there is a claim of colour discrimination in those terms. Of course, it can, in the real world, be helpful to think about colour, but that is simply not what is pleaded. Now, if I go back to paragraph 14 of the defendant's skeleton, and this is at, my apologies, I think it's 8028. Could be wrong about that, 8029 maybe. Sorry, page 8034. And if I can pick this up at 14.2, it says that these issues are background issues, and it says they do not raise any substantive claims. They're of background relevance only. We don't agree with that, and if I can, I'm sorry to keep going between documents, but if I could just go back to the pleading at paragraph 25, bundle page 25. And I'm going to give this a little bit of narrative background because I think it assists on the pleading issue. So we see that the draft of the framework, the Islamic Banking Compliance Framework, is settled, it's circulated, and then one is into the business of reactions to that. So over the page on 26 of paragraph 36, we have a series of meetings pleaded, the allegation that the claimant was shouted at by numerous then we see in footnote 3, now the background to this is that the defendant had served a further request for further information, and this was answered in footnotes by... and what is said there at footnote 3 is the conduct is relied on below of the claims under Article 59 of the Employment Law. And if one, and there's a reference then downwards, and if one goes to 40D, which is at page 32 of the bundle, one sees it said there, it's apparent alternatively fairly to be inferred that the responses to the claimant raising his legitimate concerns about the claimant issues in good faith, as pleaded herein above at paragraphs 33 to 8, were materially influenced by racial stereotyping. In particular, the reference to the claimant as a cop of the colonial era was a reference to and or depended for its meanings on his British nationality. So we don't accept that that is not a claim, and in particular I'd refer to paragraph 40J, which concludes the whole of paragraph 40, that's at page 34 of the bundle. In the premises, the claimant was discriminated against contrary to section 58(2)(a) of the Employment Law in that he was treated less favourably on grounds of his nationality. So we don't accept that this is background.
Well, as I understand it, the reference to him being a cop of the colonial era was in an anonymous email. That's right, isn't it?
That's correct.
Yes, right.
As to victimization, I'm going to just take one example of where there is a disagreement between the parties, which I think is a disagreement of principle. At page 29 of the bundle,
Yes.
this relates, we have first of all, again, to put this into context, we have the submission of the 365 feedback. It's become apparent on disclosure how important the reaction to that was. And then we have a series of matters pleaded at 40.6. Now, we then have, if we go forward to paragraph 130,
Page
61.
Thank you.
It said, materially, it's fairly to be inferred the proposal to the claimant of an MSA was a response to a protected act pleaded in 41A 40.6. And that has been duly picked up in the list of issues, and I'm not going to go there, but it's issue number 8. Now, it's correct that the list of issues doesn't say in terms, was this a protected act? But as my learned friend himself submits, the LOI isn't intended to be a nitpicking exercise, and the simple fact here is that the reference at paragraph 130A encompasses the whole of what's pleaded in paragraph 40.6. And this goes into a wider point which I would make about pleadings of discrimination, and specifically the arguments that we're seeing here advanced about pleading. There is, and if one goes back to paragraph 40.6, just for reference for the submission, sorry, the bundle page in question is 29 to 30. There is, I do have to submit, an air of unreality about the debate that we're having. We're talking about things said by the claimant to the same person, manifestly on the same theme, which have been pleaded later in the pleading to be protected acts. The attempt to draw the very fine distinctions that are being drawn here about this is not pleaded, or this is this is pleaded, but it's by way of background only, is in my submission wholly unrealistic in a discrimination claim. It is correct that discrimination law pleadings can be long documents. It is correct that there can be technical arguments about this. But here, in my submission, first, the claimant's case is adequately pleaded. Second, there is, if I may say so, an unreality to the juxtaposition of the complaints. First, that the particulars are too long, and second, that they haven't pleaded everything in sufficient detail. Not that that is an unreality with which, of course, the court will be unfamiliar, but the more important general point here is, and I'm going to some extent, cut to the chase on this. If one looks at paragraph 152, this is at pages 73 and 74 of the volume. A few points about this. First of all, one has the issues of comparator, which I've addressed. And then it says, as to the acts of discrimination, for ease of reference, the claimant was, and then there's a list. And then at 152.7, so that's the list that was there already. And then it says, subject to the further detriments pleaded above, which are, of course, compendious. And as regards the case on discrimination, we say that it is not appropriate or right now to say that issues are only of background relevance or that they are not pleaded issues. So that is where we are on that. This then feeds into a point on victimization. Now, with regards to victimization, the position is that the claimant's case is pleaded at 152B. And I would draw attention to the words, and by dismissing him. And the reason I do so is that there is an obvious point here which nevertheless calls to be made, and it's this. When one has an employee such as Mr. Mahmood, the claimant, bringing a claim, it is of course the case that Mr. Mahmood, he can make a data subject access request, but fundamentally he is not going to be party to the key emails that are going on internally between decision makers. And it is unrealistic to expect a claimant to be able to particularize before disclosure, and even in this case before evidence from which some extremely important things about who made which decision have come out. It is unrealistic to say, well, you know, because we have done this, and it may be wrong, but because you haven't pleaded it and didn't know about it, it can't be the subject of a claim. And that is, in my submission, precisely where the kind of general averments to which I have taken, Your Honour, are of particular relevance. And on that point, I don't generally find myself going to replies, but here we are, page 122 of the bundle. And yes, as ever, there's an element, I'm sure, of rhetoric here, but I will now do what possibly should be done, and to adopt paragraph 2 as a submission. Because what we see here is a position whereby the defendant has failed to plead a positive or any case to allegations which it should be able to admit or deny. It's taken an extremely unforthcoming approach throughout these proceedings. And given what is admitted now by way of amendment to the defence, it's apparent that there were a number of highly relevant matters which found no part at all in the original defence. Now, it may be said that the claimant did not plead the colonial cop era. Well, the reason for that was that he originally didn't know about it. And I do flag that while I am duly engaging with the pleading debate in its own terms, or in the terms that it's being put, we say that in claims such as the present, there simply cannot be an expectation of unrealistic particularisation or of continual reparticularisation of the claim as it moves on through disclosure. In this case, as Your Honour will be familiar, having dealt with a very long dispute about production, there were waves of production. It wasn't until October of last year that the final documents about the performance reviews came through. So we would urge Your Honour, when considering these pleading debates, to do as follows. First, Your Honour will have here in the transcripts the notes of the specific points I've developed in opening. Second, Your Honour will have the point that it's simply not accepted that the case is narrow in the way that is suggested. And thirdly, that Your Honour does need to bear in mind the general averments as to what has happened in this case. Now, this is also relevant to the issue of time limits. Now, both sides have made their submissions about the continuing act doctrine. I will refer, if I get my falling over, I will refer Your Honour in the bundle page to the authority of don't want to knock it over, thank you. To the case of Hendricks, which is in the bundle. Now, the bundle references for Your Honour are 8279 to 8294. In the internal pagination, this starts at page 231. In this, I would say, somewhat self-made, well, made by, very nicely made by those instructing me. And the key point that comes out of Hendricks is that the courts in the UK have become very familiar with the question of are discrimination claims in time. I mean, insofar as it's relevant, I should say that the position on time limits in UK employment legislation could be the subject of an extremely lengthy submission. But what I'm going to do is simply refer to this case at paragraphs 51 to 52. And what's said there by Lord Justice Mummery was as follows. In my judgment, the approach of both the Employment Tribunal and the Appeal Tribunal to the language of the authorities on continuing acts was too literal. They concentrate on whether the concepts of a policy, rule, scheme, regime or practice in accordance with which decisions affecting the treatment of workers are taken fitted the facts of these cases. And then there's discussion there. And then it said at paragraph 52, the concepts of policy, rule, practice, scheme or regime in the authorities were given as examples of when an act extends over a period. They should not be treated as a complete and constricting statement of the indicia of an act extending over a period. I agree with the observation made by Lord Justice Sedley that the Appeal Tribunal allowed itself to be sidetracked by focusing on whether a policy could be discerned. Instead, the focus should be on the substance of the complaint that the Commissioner was responsible for an ongoing situation or continuing state of affairs in which female ethnic minority officers in the service were treated less favourably. The question is whether that is an act extending over a period as distinct from a succession of unconnected or isolated specific acts for which time would begin to run from the date when each specific act was committed. Now, that is an important passage for several reasons. One can see claims where an individual brings a claim relying in part on how others were treated or how others of allegedly the same or similar circumstances were treated as a matter of fact. One can also see some quite complicated arguments developing about whether there was an institutional culture in a particular place and so on. Now, in this case, we submit the position is straightforward. There was one employee, the claimant, who was treated in the manner set out in the particulars of claim and in the witness statement over a substantial period after his move into the Islamic banking unit. The decision makers at the start, during and at the end of this case are among a discrete group of individuals, all of whom are known, or all of whom are now known, I should say, all of whom, or subject to immaterial exceptions of which I am unaware, are still at the bank. The claimant's line manager, Mr. Long, was his line manager from the beginning to the end of his tenure in Islamic banking. The CEO and COO of the Islamic banking unit were, and as far as I understand it, remain the same people. The people, the key person in ER who dealt with this case was...
I don't think that's right. Mr. Sheikh's moved on. The CEO of Islamic banking.
Sorry, that's right.
Mr. Sheikh is now heading up the bank in Pakistan.
That's right, sorry. Yeah. But I believe I'm right in saying, hang on, let me just double check. This is at the start of his statement, I seem to remember, isn't it? Apologies. Don't want to get this wrong. I think what's said is that he's now in Standard Chartered in Karachi, I believe.
Yes,
that's
right.
the case.
He's head of the bank in Pakistan.
Yes, exactly, that's right. So, the correct submission is these are all people who are still in the bank.
Yeah.
So this is not a case where, this is also a case where the documentation, as Your Honour will have apprehended from the bundle, is very substantial indeed. So it is not a case where you have a claim being brought about things that no one really knows about. And it is also a case where, for the reasons I've taken Your Honour to in the reply, but examples could be multiplied. For example, when the performance plans came out, when a lot of the internal emails between ER and various people came out. This is a case where, if I am wrong on continuing act, which I do not accept at all, but were I wrong on that, we would say that this would be a powerful case for an extension of time.
What are are there any authorities dealing with the factors that I should take into account in deciding whether or not to extend time?
Within this jurisdiction, not that I'm aware of, and the wording, as my learned friend may point out, is not the same in the two statutes.
What then do you submit are the factors that I should take into account in deciding whether to extend time if it comes to that?
Just getting to the precise wording. My apologies. what is said in 61(2)(b) is where a complainant satisfies the court that there are circumstances which justify disapplying Article 61(2)(a). And what we submit are going to be, I mean, the first point I would make is that a full submission on this is going to have to await what comes out in evidence.
Yes.
And that's an important point. I don't want to preempt cross-examination, not least because it can go very wrong if one does that. But if and insofar as there are points here that have not been addressed by the bank in their witness evidence at all, and which emerge from the course of evidence, and which make a material difference to how decisions were taken and what the claimant can be presupposed to know, that will be relevant. That ties in with my wider point that our submission, just to be straightforward about this, is that really it has only been once one has the colonial cop era and other things out in the open, which they were not, that time should begin to run. And this claim was, of course, brought before that.
Right, so one of the factors you identify is knowledge.
Yes.
I assume another factor that you would rely upon, if it comes to an extension of time, is the proposition that the commencement of proceedings during the course of employment could have exacerbated prejudice and detriment.
That's exactly right. And then the next factor I would rely on, which I think is quite an important factor, is that in circumstances where there is a time limit running from the date of dismissal and settled law that it's the dismissal itself taking effect, which is where the cause of action accrues, as it were. We say that really this is not a debate about a claim being brought out of time, because the claim is being brought in time, and the question is whether the acts leading up to the termination of the employment, the primary question is, are these all part of a continuing act? And the second point we would make is that it is only when the story has come to its end that the claimant really is in a position of having to bring proceedings or not. And there's a particularly important point about this, which I would, it's a technical point, but it is an important technical point. Within the UK, there is settled jurisprudence about how damages or declarations are awarded or made, as the case may be, for detriment suffered in employment by employees who remain employed. But in my submission, the claimant here, had he submitted proceedings during the course of his employment, would have been really taking a leap in the dark as to what remedy the court would have granted him. And I do think that is an issue of some significance. And finally, there is on the English decisions that the issue of the merits of the claim also comes into play. And the reason for that is very straightforward. In the United Kingdom, the lodestar is the test of what is just and equitable. And the court has to perform, in a sense, a balancing act between a defendant or a respondent, as they call it in the UK, being vexed with a stale claim on the one hand, and on the other hand, the fact that a wrong has been committed. And it is, of course, all to be understood in the context that these time limits, Your Honour will not need any development at this point, these time limits are short. And so, really, when one is talking about a stale claim, that in my submission there isn't really an equivalence with claims that have been left fallow for 5.5 years or anything like that. So that is where we are on extension. Now, in terms of the bigger picture on this, I am not in this opening going to develop in detail the way that the claimant feels about what has happened, views of the bank's conduct, and so on. What I simply say is that if the facts of this case, as alleged, are found by this court, it will follow that an extremely serious series of wrongs have been done to the claimant. And what makes it all the more striking that that has happened is that we are dealing here with an international bank with very considerable internal resources and indeed access to external resources. And so it can't plausibly be said by the bank, oh, well, we didn't know about any of this. You know, we weren't aware of the new law. We didn't know we could do this. We weren't meant to do this. And we say that what has happened is particularly egregious. Because in a sense one sees a series of attempts to force the claimant out of the bank. So one has a disciplinary, one has the offer of a separation agreement. Now, you know, leaving anything else about a separation agreement out of this, I mean, if you're offered a separation agreement, I would suggest it's self-evident that the person offering you that settlement agreement doesn't want you in their employment. And then one has a dismissal about which Your Honour has seen our case. So we say that this would be an appropriate case for under the law of damages and remedies. Unless I can assist Your Honour further, those are my submissions.
Thank you, Mr. Bickford-Smith. Mr. Seddy.
There's just one housekeeping point I should mention in closing, which is this question of closings.
Yes.
This was discussed at the PTR.
Yes.
Effectively, at that stage, the question was: Are we going to get the case into the 10 days? The answer to that is yes, we will be able to get it into the 10 days in terms of the evidence. But having regard to the volume of the witness evidence and the volume of this bundle, we say that this is clearly a case where we're, you know, I would love it if I were proved wrong and everyone starts going short, but realistically, this is a case where an oral closing should be delivered after written submissions. Those are submissions. I would reiterate our main preference is that the oral hearing should follow the written submissions. I know that the RDC contemplate the other way around, but we want written submissions and then an oral closing so that matters can be addressed.
And have you conferred with Mr. Seddy in relation to dates?
That is a long process. I had thought that we were going to be done early in April, but that isn't doable. At the moment, we've got a date for the closing submissions themselves on the 25th of March, and the first day available for the mutual convenience of everyone is the 1st of May, and I have to say we are over this week going to be trying to get that earlier because we do want it earlier.
All right, well, I'll leave you to confer and there we go. All right, thank you, Mr. Bickford-Smith. Mr. Seddy. I just mentioned, Mr. Seddy, I think we'll take a break at about 11:30, if that's convenient, and I think we'll introduce that as a regular break into the program. I think 3 hours is a little too long in one sitting, so we'll take a mid-morning break around at some convenient time around 11:30. We'll break for about 10 minutes.
Thank you, Your Honour. That's very helpful. So around 11:30.
Yes, around 11. Whenever, there's no magic in that particular time, but whenever's convenient around that time.
Well, Your Honour, let me start where my learned friend ended. I hope to be short in opening. Your Honour has helpfully indicated the extent of pre-reading, for which we're very grateful. This is a substantial piece of litigation. We've got 10 days. My learned friend's indication a moment ago is that he confidently expects at least the evidence to conclude. And certainly that is the plan. And we will have post-evidence written closing submissions exchanged and an oral one-day remote hearing
Well, I think we have to make sure the evidence does
Yes,
conclude within
absolutely.
that time. If there's any threat to that, we'll just sit longer hours.
And that is one of the reasons, Your Honour, why I'm very keen to ensure that openings are kept as brief as possible and we get into the evidence. And not least because of the submissions I'm going to make on the substantive pleaded claims, the background claims and the unpleaded claims. There are 4 causes of action in this litigation that are live. There is less favourable treatment because of nationality or race, contrary to Article 59(1)(c) of the 2019 Employment Law. There is victimization because of the doing of a protected act under Article 60. There is harassment related to nationality or race, contrary to Article 51(c) to D. There is a separate claim for a fine, which is being sought under Article 43(2) of the Employment Law, which we can address in submissions later. Can I deal firstly and briefly with the list of issues point? You'll have seen, and I couldn't help but notice in my own friend's opening, that when it suited him, he wanted the list of issues to be a definitive, almost pleading-esque document, and then later was saying that the list of issues is not a nitpicking exercise when it suits him. It's important to understand what the nature and status of the list of issues is. It's a roadmap. It's not a replacement for the pleaded case. And of course the court's jurisdiction is limited to the pleaded case, as it is in England. There's a Court of Appeal authority of Chapman and Simon, which indicates it would be an error of law for a court to determine a claim which is not pleaded. For example, Chapman versus Simon. It's not in the bundle of authorities, but certainly it will figure, I'm sure, in closing. And the important point is this. Whilst my learned friend wishes to, in his written opening skeleton, barely touched upon the deconstruction of the pleaded case, it is absolutely of the first importance that before a trial of this nature, one really does understand what are the causes of action that are pleaded as substantive detriments upon which the claimant is inviting the court to make a declaration of liability for unlawful discrimination or harassment or victimization. It's critical. We all need to understand, and Your Honour, I'm sure you will appreciate the importance of this. We all need to be absolutely clear when we're treading across the entire narrative in this matter, whether we're dealing with a matter which is just of relevance to a pleaded detriment, or whether it is something not pleaded at all, and whether we then therefore need to move on. Because there is an awful lot of ground to cover in this hearing. So it's absolutely important at every turn that we understand what relevant point the evidence is going to. And that's why I say that, and the list of issues itself, that was agreed, is in its introduction, states in terms expressly that this list of issues is served without prejudice to the parties' pleaded cases. You'll see that headlined in the opening paragraph of the agreed list of issues. That's normal. It wouldn't need to state that. The list of issues is there as a helpful aid memoir or roadmap. But the start and end of claimant's case as to what it is in his amending. Now, Your Honour, I'm not going to spend a great deal of time rehearsing the observations I made in my opening written skeleton as to what is substantive, what is background, what is not pleaded. But it is important the claimant has always been represented by expert local employment lawyers, both when he issued his initial claim with his first firm of solicitors, and then when he moved to his current firm and served the amended particulars of claim. These are carefully, conscientiously pleaded documents. they make it quite clear, as they should, where matters. There's an awful lot of fact referred to in the amended particulars of claim. It's a long and at times difficult to follow document, but nevertheless, when the claimant is pleading a cause of action, he makes that very clear. And I trust that in my opening written skeleton I've given the cross-references to the relevant paragraphs within the amended particulars of claim, where he ties his colours to the mast. He says this occasion, this event, this act is an unlawful act of direct discrimination or an unlawful act of victimization or an unlawful act of harassment. Where he's clear about that, that's because he's relying upon them as substantive detriments which he seeks to obtain a declaration from the court and remedy in relation to. The other matters, as is often the case in a discrimination case, is to be treated by way of background relevance only. So the mere fact that they're mentioned in a pleading means they're relevant, but it doesn't mean that it gives rise to liability.
Well, I'm having some trouble with that because, and it's probably a function of my age, Mr. Setti, as you can see, I'm quite old. I go back to the time when I was a young lawyer. There was a hint of the sort of approach to pleadings that was taken in the 19th century when only facts were pleaded. And so the pleader's task was to set out the facts, and the pleader made very little reference to any legal connection between the pleaded facts and the entitlement to relief. Now, of course, that's morphed over time. But when one views it from the perspective of the function of pleadings, which is, of course, to alert a party to the case that it has to meet, then if a fact is asserted, then the party is on notice that that fact has to be met. Does it matter whether it's characterised as background or as an essential element of a particular cause of action? Why does it matter?
It matters for this reason. A claimant could produce a 1,000-page particulars of claim with a lifelong narrative over a decade. How is a defendant to know the legal case that it has to meet in relation to each event that is said to give rise to liability, or each act?
Well, that's an extreme example, but it's
well,
not this,
even in this case.
But it's not this case. This case, there is a factual narrative that is set out in the pleading. It's augmented, of course, by the witness statement that's been served in support of the pleading. And so, and the other, I mean, the practical reality is, if I were to accede to any of your pleading points, then procedural fairness, I think, would require me to indicate that to Mr. Bickford-Smith before the trial is concluded and give him the opportunity to apply to amend, and that amendment would be allowed unless you can demonstrate prejudice. Now, if you've been on notice of a fact being in contention, of course I'll wait and hear you. If we get to that point, I'll wait and hear you.
Yes.
But if you're on notice that a fact is in contention, it's going to be hard to assert prejudice, I would have thought.
Your Honour, I think we're at cross purposes. I'm not suggesting for a moment, as is well established in the English trials in these kinds of cases, I'm not trying to seek to persuade Your Honour for a moment that you are to exclude any evidence that's referred to in the particulars of claim, or that I don't have to deal with it even if it's by way of relevant background. It's relevant evidence. The issue I'm going to seeking to explain here is what are the unlawful events complained of that give rise to a declaration of unlawful discrimination, unlawful victimisation, unlawful harassment. It's those events by perpetrators which need to be identified and understood.
But if it's not going to impact the evidence, then I get back to my point, where's the prejudice?
It's not a question of prejudice. I'm going to deal with all the background evidence
All right.
in the hearing. So I'm not seeking to limit at all the nature of the evidence that's to be called. We're going to be going through a great deal of factual evidence. The question is, Your Honour will want to know what it is that you're being asked to decide and declare at the end of the case, and that has to be anchored by reference to a finite series of acts of unlawful discrimination. So, for example, when one is looking to establish whether there is a continuing act, you're not looking, as my learned friend might suggest, just to see whether there is some form of factual connection between a stream of events. You're actually looking to see whether the pleaded substantive detriments of discrimination are connected.
Why would I do that? Why wouldn't I look to the evidence? Why wouldn't I just go to the evidence and then ascertain, apply the test in Hendricks of whether there was either an act extending over a period or an unconnected and isolated specific act?
Because Hendricks isn't the last word on the subject, there's been subsequent Court of Appeal decisions. Hendricks was a Court of Appeal decision of some vintage now. There have been subsequent, more recent Court of Appeal decisions, such as Aziz and FDA, which is in your honours bundle of authorities, which indicates that a highly relevant factor is whether the same individual is said to have treated the claimant in respect of each identified substantive detriment, and whether there are other connecting matters there.
I think with respect that reinforces my point. That is that the answer to the question lies in a consideration of the evidence, not a detailed analysis of the pleading. And again, I get back to the point. If the facts that are an issue are known to you and you don't dispute that, then isn't the rest? I'm just struggling to see why we would need to go into a detailed analysis at this stage, or indeed at any stage, of how the facts are pleaded for the purpose of ascertaining remedy. Really, that's a matter for closing, and it's difficult for me to see how you could suffer any prejudice. And so, in other words, pose the test. Let's say I were with you and say, all right, there hasn't been a specific pleading of this point, therefore, on the pleading as it stands, I can't take those facts into account for the purpose of establishing that cause of action. If I came to that conclusion, I would then be inclined to invite Mr. Bickford-Smith to apply to amend. And if there would be a limitation issue, of course, in relation to the amendment, but again, one would go back, there's all those cases about whether limitation turns upon when the facts are put in issue rather than when the legal connection is enunciated. There's all that law. But ultimately it would come down to a question of prejudice, and it's difficult for me to see how you would ever win that argument.
I think Your Honour is concerned that I'm trying to limit the claimant's evidence. I'm not at all, or any of the evidence that the court will hear. Well, it is a matter for closing.
I'm just struggling to see the point of it, because I can't see that it actually leads anywhere substantive.
I say it leads somewhere substantive in closing, and I can refer in closing to Your Honour, to authorities on the point. But it was simply the observation that there was a lot of evidence in this case over a long period of time, from 2017 to 2021, and it would be helpful, I say, for an understanding as to what are the key events of which the claimant complains as an act of discrimination. And obviously, everything in between is to be taken into account. But it's when we reach those key events, because one is focusing intensely on who the alleged decision maker is, what the mindset of the individual is, what the motivation is. And it's not every single event which is said to give rise to a liability for unlawful discrimination in this case. It's almost as simple, as fundamental a point as that. Can I just deal with some other matters? The Claimant's counsel sought to clarify that for the direct discrimination claim, he seeks to rely upon two comparators, or two racial or nationality definitions. One is that he said to be a British national of Asian origin, of Asian race, to use the pleaded case. In short, we will refer to that in the evidence as his case that it's because he is a British Asian that is being treated in the way in which he complains. That is understandable. We understand that claim.
Well, the case as I understand it is that he says because he's a British Asian who has not embraced his Pakistani nationality. That's, as I understand, the way the case is presented on the evidence.
Well, that then leads me to another point, and that is that as the developed English authorities make clear, one can't change the reason why the claimant says he's treated in the way in which he is. And so one needs to be clear at the opening, what is the reason why the claimant says he was treated badly? So is it just because I'm British Asian, or is it British Asian plus some other element, as your Lordship, as your Honour has just identified? And if that is the case, then we would want absolute certainty on that, because those are the matters that need to be put to the witnesses as to whether they were motivated by not just the fact that he was British Asian, but it was British Asian plus something else.
Well, that's what Mr Mahmood says in his witness statement, so that's what I'm going on. Mr Bickford
Very
Smith, have I misapprehended the case?
Shall I do this now?
Yes, that would be convenient, I think, because Mr Setti says rightly he needs to know before cross-examination.
Can I don't have the immediate page number for it, so I'm just going to find it.
I mean, it's simple yes or no as to whether it's as your Honour has stated.
So
all I need to know.
The position here has been set out first in the pleading, then at paragraph 33 and 34 of the skeleton. I think what my learned friend is after is about the Caucasian point. I think that's
No, it isn't.
No, I'm not talking about the comparative.
Oh well, then the answer is yes. The answer is yes. Then sorry.
The answer is yes. So it is as I put.
Yes, that's right.
All right.
So I'm clear that the claimant is saying, in most respects, his, as it were, nationality discrimination claim is, I was treated to my detriment because I'm a British Asian who has relinquished, or perceived to have relinquished his Pakistani.
At least not embraced it.
Not embraced his
not embraced.
Pakistani.
Yes.
I shall find the exact
Yes.
wording from the pleading, but so we understand that.
Yeah.
That's very clear. Thank you. I was therefore oversimplifying the basis upon which he was first kind of claiming direct discrimination. Now the second basis, and I'm only raising this now because my own friend mentioned it, because he sees that in my paragraph 7.53 of my opening skeleton, I raise the fact that he appears to be raising skin colour discrimination. I think my learned friend sought to clarify that it is because he is not Caucasian, so it's in the negative, that he's being treated to his detriment. It's nothing to do with his skin colour. The difficulty my learned friend has with that submission is that the very definition of Caucasian is that you are white-skinned of European origin. That's the difficulty he has, and that's why we sought to clarify that this is a case that he's bringing in the alternative because he's not a white-skinned of European origin, because that's the definition.
But isn't that well, most races are identified with skin coloration? Not necessarily. I mean,
not necessarily.
Not necessarily, but very often. So, how do you distinguish between reliance upon a race, which is or an ethnic origin in the case of Caucasian, as compared to skin colour? I mean, skin, as Mr. Bickford Smith concedes, skin colour alone is not a prohibited characteristic.
Well, it's the pleaded case is that he is not Caucasian as the alternative ground as to why he was treated to his detriment. And if that's the case, well, then the meaning of Caucasian is that it's somebody who's white-skinned and of European origin.
Well,
but if it's simply saying I'm not from Europe, if that's the basis, we need to understand that.
I think there's a bizarre misunderstanding. The point that I was addressing, and apologies if I was not clear about this, the point I was addressing in opening was that, put very simply, we say this argument about skin colour in the sense of, oh, there is a skin colour claim being run here. We say that's an Aunt Sally. The point is that the word white Caucasian, for the reasons stated, is a sort of, I've forgotten the correct word, but it's when you say two things which have the same ultimate effect. I mean, the second word is redundant.
Well, your case, as I understand it, is that the ground of discrimination was, as we've just discussed, that is British Asian who hadn't embraced it back. But you're saying that, on the other hand, you can take a Caucasian comparative because there was was, if you like, a white men's club.
That's exactly
within
right.
within the bank, and he wasn't.
That's right.
Wasn't accessible to that either.
That's right.
But I have to say, and I understand, gentlemen, you both have much more experience in the world of discrimination law than I do, and I understand that this issue of comparators is steeped in the English jurisprudence. But in this case, I'm struggling to see how it's going to help me a lot, because in this case, I think the factual questions that are posed for determination are whether the events that occurred to Mr. Mahmood were as a consequence of the steps that he was taking to try and introduce reform into the Group Islamic banking section, on the one hand, or whether they were motivated, at least in part, by the characteristic of which he complains. Now, I don't know that I'm really going to be helped in answering that question by envisaging in my mind any other form of comparator. It's really just going to be my assessment of the evidence as to what the motivating circumstances were, isn't it?
Your Honour, we say in a direct discrimination claim, it is of the first importance, it's fundamental to the claim to understand the reason why and whether that reason was on a prohibited ground. And in order to understand that, one needs to have an understanding, an agreed understanding of what is the defined ground upon which the person is said to be motivated in a mala fide way. And if one doesn't do that at the first hurdle, at the first encounter with the problem, if one doesn't grab that nettle and have that, then one is not applying that to the case as to what was motivating, or whether those prohibited grounds were motivating the individual. So, for example, with this Caucasian debate that we're having, is it because you are not from not a Western European individual, or is it because of the colour of your skin, or both? Those are actually very important, critical matters to the declaration of somebody being treated less favourably because they're not Caucasian, for example.
But I don't understand that to be Mr. Bickford-Smith's case.
Let me take you to
I
paragraph
understand
1.
Mr. Bickford-Smith's case to be precisely as you pointed out. His case is that the discrimination was because Mr. Mahmood was a British Asian who had not embraced his Pakistani origins. Now, he's not saying I was discriminated against because I'm not Caucasian. The case is that a Caucasian person is in a comparator, and as I understand it, the way that possibly might work is this, and again, Mr. Bickford-Smith will tell me I've got this wrong. The allegation is that the people within Group Islamic banking were motivated to resent Mr. Mahmood's interventions because of he was a person of British Asian who had embraced his Pakistani heritage. Now, clearly, that's not an allegation that would run against people like Mr. Long or Mr. de Groot. So, as I understand it, the proposition is that although the discrimination occurred within the Group Islamic banking section, the relevance of the comparator is that had Mr. Mahmood been a Caucasian, then people like Mr. Long and Mr. de Groot might have been more sympathetic to his complaints. Have I got something wrong there, or is that?
When one looks at paragraph 152 of the amended particulars of claim,
Where do I find that? Trial bundle page.
page 73.
Thank you. Yes.
For the main discrimination claims, if you like, direct discrimination claims, it says there that the claimant's case is that the appropriate comparator would be a hypothetical comparator who was not a British Asian, but a Pakistani national of Asian race.
And that's clearly a reference to discrimination within the Islamic banking group, I imagine.
Yes. And then it says in respect of the treatment meted out to the claimant by the management of the defendant's compliance function, the claimant's case is that the appropriate hypothetical comparator would be a Caucasian person with white skin.
Right. So that's okay. So
Do you see where I get
yes,
that from?
Yes. Well, but that's, I think, consistent with the point I was making. That is that the discrimination is on the basis of, as we've discussed, British Asian without embracing Pakistani Pakistani, but in relation to the treatment provided at the upper levels by people like Long and de Groot and Phoebe, then the proposition is that a relevant comparator would be a Caucasian. But that doesn't change the basis of discrimination.
Yeah, I'd say it does, because if you change the comparator, you're changing the basis of discrimination. Right. In a nutshell.
Right.
It's worth noting that, Your Honour, because what he's putting it two ways. He's putting his direct discrimination case two ways. And let me try and paraphrase. He's saying, I was treated badly in a circumstance where British Asian, who has not embraced their Pakistani heritage, would not have been treated in the same way. Alternatively, on some other occasions, I'm saying I was treated badly because I'm not a white-skinned Caucasian. He's putting his direct discrimination case in two respects, as pleaded at paragraph 152.
Right.
And he has to do that. It's a bit like when he changed the definition of his own race in paragraph 7 of his particular claim, because when non-Pakistanis are meting out the treatment to him, he says it's for a different motivation, a different discriminatory intent. And that's why he has to run it in the way in which he does. I just needed that to be clear, and I think it's a helpful discussion that we're having here.
Yes, thank you.
Can I just... Your Honour will have seen the observations I've made in relation to DIFC direct discrimination law and English direct discrimination law, and the relevant authorities which seem to be of some pertinent relevance there. It's set out in the written skeleton, yes. I'm not going to repeat that. And in relation to victimization and harassment. And in relation to victimization, the amended particulars of claim is very clear as to what the protected acts are. And I've set those out. There are four pleaded protected acts. It's crystal clear what they are. It is only those four. And it's important to understand those because when identifying the victimization claim in closing, one needs to know whether it was one or more of those four that affected subsequent matters. And in relation to those subsequent matters, I've identified the 5 pleaded acts of victimization. That's what I call substantive unlawful acts of victimization in paragraph 9.4 of the opening. In fact, there are 6, if one includes the dismissal. And Your Honour, in relation to harassment, I've identified the 4 acts of harassment in paragraph 11.2. I understand that no disagreement has been taken by my learned friend in relation to the correct identification of those matters. If there is to be a disagreement on that, we need to know, and we need to know now.
Mr. Bickford-Smith?
Yeah, well, there is absolutely, yeah, because I've just got to get the reference. The green point about, sorry, I've got to note paragraphs. I think the relevant bit here is not actually in paragraph 14, it's my learned friend skeleton, it's in paragraph 15.33. 8045, harassment. It says the last act of alleged harassment is harassment 4. Mr. Shah's decision, right. Going to the pleading. B.1.
Page number?
54.
Sorry?
54, my apologies. 54.
Sorry, which was the paragraph again?
101B1.
And what does that relate back to?
So it refers to 59.2. 59.2 encompasses harassment.
Yes, so, but then the fact that the act that's being referred to is the appeal outcome, is it?
That's correct.
Where are we looking?
It's 101B, is it?
101B or 101B.1.
So you say the last act of harassment was the outcome of the appeal. Are there any other matters in which you disagree with Mr. Setty's characterisation of your case?
No.
No, right, thank you.
I'm grateful to that. That's very helpful. So,
Thank you.
this matter of Mr. Zulu's disciplinary appeal decision on the 5th of July 2020, we are agreed, is the last act of alleged harassment.
Yes. Thank you.
Very good, thank you. So that will become harassment number 5, which can be added to 1 to 4. And for your honour's note, that's issue 23
Thank you.
in the list of issues. Another matter that will figure heavily in closing will, of course, be the fact that mere unreasonable treatment is not less favourable treatment. The mere fact that something has happened after a protected act and may not have happened but for the protected act doesn't mean to say it happened because of the protected act. So merely having a sequence of connected events isn't enough to establish legal causation. There'll be other similar submissions made. Another point to highlight is the burden of proof. The burden of proof provisions in DIFC employment law differ to those under English law, so English cases have a shifting burden of proof and deal with matters in a different way. Here, Article 61(1)(a) stipulates that the burden of proof remains on the claimant, and I submit at all times, both the evidential and legal burden. And given that the only characterisation issue that's arisen is in relation to adding another harassment substantive claim, Your Honour, the analysis that I've undertaken in the opening skeleton, therefore, is our understanding of the case that we have to meet legally. Of course, we're not closing any avenues for giving any relevant evidence in support of any of those.
Does that mean that the debate we had earlier about pleadings is...
This is the point I was making, Your Honour.
Yes.
I think you were thinking that I might have been seeking to somehow narrow the evidence to be heard. Not at all, not at all, not for a moment.
Okay.
Let me be very clear on that. It was all to understand, and this is perhaps a taxonomy issue. When I refer to a substantive complaint, a substantive detriment, I mean an alleged act of unlawful discrimination or victimization or harassment upon which, according to the pleading, the claimant is inviting the court to make a declaration of liability. Everything else comes into the mix in support of that or not, as the case may be, but doesn't found the claim. Now, and that's why I say it's important to understand before when listening to the evidence, what is substantive detriment, what is something he complains about, but actually it's not substantive detriment, it's some other detriment, and that which is not pleaded. But everything of background is of relevance, so I'm not excluding. This is a matter, Your Honour, in which we're going to need to deal with matters relatively chronologically. And this is a claim in which the claimant complains of a conspiracy. There's no other way really to describe it. He has to make good his claim, particularly in relation to a continuing act, that a great many actors are combining to his detriment from 2017 right through to 2021. Brings me on to one other point, and that is now time limits. There is no, because of what we just established in relation to the 5 harassment alleged detriments, there is no harassment claim which is in time. So on the harassment cause of action, the claimant will be indulging the court to seek to extend time. In relation to because he says the dismissal, which is the only event which is in time, the only substantive detriment which is in time, in order to, if you are against him on whether the dismissal is an act of unlawful direct discrimination or victimization, then all of his claims are out of time. And he will be seeking to persuade you that time needs to be extended. And on extension of time, if, let's say, everything is out of time, he will need to indulge this court to exercise its discretion under Article 61(2)(b). And in relation to each detriment that is out of time, the court needs to be satisfied that there are circumstances which justify disapplying the 6-month time limit.
Do you have any submissions as to the factors that are relevant to the exercise of that discretion?
Well, I'm coming to.
Good.
Now, Your Honour, just before I do, he described the DIFC discrimination law time limit as very short, as a reason almost for why time should be extended. Well, can I just bluntly say it is an irrelevant factor that the claimant has 6 months to bring a claim. That is the determination of the ruler, and one doesn't go behind the intent as to why these limitation periods are there. Or one has to appreciate why they're there. They are there to bring claims such as these promptly. But it's not a very short time limit, because under English law, the time limit is 3 months. And so the various authorities that you'll be taken to, the English authorities, are in the context of a time limit which is half my learned friend's description of a very short DIFC time limit of 6 months. And it's in the context of that that you'll be appreciating the authorities on whether time should be extended. There is another observation to be made at the outset on that, and that is that the language of the extension provision, coming to the relevant factors, is that of reasonableness. It is not the English language under discrimination legislation there of just and equitable extensions. And there are 2 types of extensions of time under English statutory employment law. One that relates to claims such as unfair dismissal, and one that relates to discrimination claims. In relation to discrimination claims, there's a just and equitable discretion to extend time. In relation to unfair dismissal claims, there's a discretion to extend time where there are circumstances which made it not reasonably practicable for the claimant to bring the claim within time. The language of not reasonably practicable appears analogous to the language used in Article 61(2)(b). In other words, when the court says, looking at the circumstances, was it reasonable for the claimant to bring the claim within 6 months of the act complained of? And secondly, if it wasn't reasonable, what further period would be reasonable to bring the claim within? And did the claimant bring the claim within that further reasonable period? And if he didn't, then the detriment remains out of time. One other point that arose in opening and why I raise it now. In discussion with my learned friend, Your Honour...
Sorry, is that all you understand, extension of time?
No,
Right.
I'm dealing with a factor point.
Yes, right.
You clearly identified the claimant's knowledge, the claimant's state of knowledge as to whether he thought he was being discriminated against. That is relevant. But a second point arose soon thereafter, and your Lordship mentioned the notion that issuing a claim during the currency of the employment relationship might be a relevant factor in extending time. Now, I can certainly say very emphatically that under English law that would be an irrelevant factor, the fact that the employment relationship is continuing in seeking to apply an extension of time discretion. Because there is no, if the Parliament in England or if the ruler here intended that these employment claims should generally be brought after the termination, discrimination in employment claims should generally be brought after the termination of the employment relationship, one would expect that to be stipulated. But here we have provision for employees to bring claims at any time.
I'm not suggesting that the currency of employment is a relevant factor in every case. I'm simply suggesting the circumstances of this case, so that on Mr. Mahmood's case, he says that by the middle of whatever year it was, by the middle of the year, there was an attempt to get him to leave the bank voluntarily when he was presented with the mutual separation agreement. Around this time, he was told that the ICEE process may result in his position being abolished, which eventually happened. He then had to apply for the modified position. His view was that he was being victimised because of the complaints that he had made in the past. He, I expect, would say that if he were to then have commenced proceedings, his prospects of obtaining the position for which he was applying would have been negligible. And so he would have, so in those circumstances, he had a reasonable reason for not commencing proceedings until such time as he was, at least as he was advised of the outcome of his application for the amended position which was given to Mr. Patel.
If there are certain periods of time, Judge, where it's considered he could be forgiven for not litigating, pockets of time.
Yeah.
But of course, one has to look at each substantive detriment of which he claims declaration from this court and ask, why did he not bring a claim within 6 months of that detriment? That's the point.
Yes,
There may be occasions where you can apply a discretion and say, well, you can be forgiven
yes.
for pausing to reflect maturely on the matter. On Continuing Act...
Would this be a convenient time, Mr. Setti, or are you almost finished?
I believe I'm let me just check. Yes, it's convenient time.
Yes, all right. We'll adjourn for 10 minutes.
All rise.
Just extract those pages. It just helps them get.
seated, please. Mr. Setti.
Your Honour, yes. Developing the point about continuing act and that concept.
Yes.
Now, in English law, the concept of conduct extending over a period.
And the reference in Hendricks to an ongoing situation or a continuing state of affairs. Now, those words might seem to be quite generous in terms of seeking to identify whether there are connected acts. And one can understand when one is telling a narrative, a story, or this happened, and then that happened, and then that happened. There is clearly a connection, at least in narrative terms. That doesn't mean that the act is continuing. What does that mean? Is the act continuing over a period? Now, the act has to be the unlawful act. And can I just make this proposition quite clear? An alleged act cannot be said to form part of conduct extending over a period for the purposes of the legislation where that act is not discriminatory within the meaning of the law. So what the court will do is hear all the evidence, make its findings of fact on all of the evidence, apply the law and make its findings of liability, of which acts are made out as unlawful. And then it is only those unlawful acts which can possibly, even arguably, be said to be relevant to the continuing act concept. So it's about connecting the unlawful acts, not just connecting acts. If that can be clear. There's authority for that proposition in a case called South Western Ambulance Service and King, which is in the bundle of authorities, and you'll be taken to that in closing. A second issue on conduct extending over a period which is relevant, and that is the proposition that there is a fundamental difference between a one-off act or decision which has continuing consequences, for which you might hear subsequent evidence, and conduct which extends over a period. The 6-month time limit will only run from the one-off act with ongoing consequences. And so it's vitally important to identify the act to which the pleaded complaint relates. And as I alluded to earlier, thirdly, there is recent Court of Appeal. You'll recall Hendricks' Court of Appeal. The recent Court of Appeal authorities in 2 cases, for example, Aziz and FDA, and LIFAR and Brighton and Sussex University Hospitals, which really seek to, in one sense, clarify, but have the effect of limiting what might otherwise seem to be a generous reading of the Hendricks, more nebulous concept of a state of affairs. And there it is said that where there is many different acts or omissions said to have occurred over a long period of time and by different people within the employer, a significant factor on identifying whether the act continues is whether different individuals are said to be responsible for the different acts.
But again, the relevance of that would turn upon whether there was, as you earlier described it, if you like, an overarching conspiracy amongst those individuals. So in that case, the fact that they were different individuals wouldn't be of much significance, would it?
No. If you find that A spoke to B and they conspired to do the claimant down because of a protected characteristic, then the relevant motivation on B would be there. But the mere fact that A might be motivated by discrimination doesn't necessarily mean that B is, even if B treats the claimant to his detriment. So you'd have to find that communication between A and B. In this case, we have A to B to C to D and more onwards, far further onwards than that, because the claimant seeks to suggest that from everything that, I don't want to be flippant, but in a sense he's saying that everything that bad happened to him from end of November 2017 to beginning of 2020 is all motivated by, no matter who did it, it's all motivated by his race or protected acts.
There was beginning of 21, wasn't it, when he was terminated?
Terminated beginning of 21.
Yeah.
January, really, it's end of 2017 to the end of 2020.
Yeah.
But we are looking at a long period of time. Your Honour, the screen supplied here by the court has gone blank in front of me.
All right, we'll send out for AJs.
It's come back on.
Oh, good. I probably cursed it by telling the technician how well the technology was working during the break. That's probably what caused it.
It's certainly deeply impressive. I wish we had the same back home.
This is the second trial that's been conducted in this court, so we're still, last week was the first, so we're still teething our way in, but it should be okay.
That's a real honour. Now, Judge, I'm conscious of the time. I'm very keen to get on with the evidence.
Yes, certainly.
So unless Your Honour has any questions arising from my opening observations.
No, I don't. There's a couple of matters that I want to raise with counsel generally of a practical nature and really, if you like, in which I'm seeking counsel's assistance. The first relates to the chronologies. And you can sit down, Mr. Setti, while I go through this. There are two chronologies, and I understand how that comes about. But I view the chronology as a very helpful guide to judgment writing, to be frank, and I'd like to use what we've got now to build a document that would be quite unashamedly of assistance to me for that purpose. And the way I would like to go about doing that is by combining the two chronologies. Of course, where there's duplication, only one entry needs to be included, but where there isn't duplication, they can be combined. I don't think the description doesn't matter because, of course, the chronology isn't evidence. It's just a statement of a party's contention. What is of greatest use to me in a chronology is the evidence that pertains to the item in the chronology. So what I'd like people to focus on, and this can be built by those who are assisting you, gentlemen, over the course of the next couple of weeks, is that the combined chronology, and it should be expanded to include basically any event that you think is significant enough to warrant attention in the judgment should be included within the chronology. In relation to that event, what would be of assistance to me is if you could identify the documents in the trial bundle by reference to their page number, which are relevant to that event, any paragraphs in the witness statement that are relevant to that event, and any oral testimony that is relevant to that event. So obviously, this will be an iterative document that will grow during the course of the hearing. But it would be of great assistance to me as a tool to judgment writing, and I suspect, gentlemen, to you as a tool for preparing written closings, if that's the way we go. So I wonder if I could put that request out, and if there are any problems with it, come back to me. The next issues really concern the trial bundle. There are, of course, many documents referred to in the witness statements in the trial bundle, which presumably were attached to the witness statements at the time they were filed, but the witness statements have now been segregated from those documents. So my question is, how do I find in the trial bundle the documents that are referred to in each witness statement? Mr. Bixford-Smith, I think you were first off the mark.
I defer to
Mr. Setti.
I'm grateful. There are two sets of witness statements in the bundle.
Right.
The second set, the latter set, towards the end of the bundle, the page references have been updated.
Right.
To
So they're the
reflect
ones in
those
section I, are they?
They are the ones, yes. If I can take Your Honour to the index.
Yes. I don't seem to have the index on my screen, but anyway. Just got the bundle.
In fact, let me just give you the page where they start. 7410
7410.
is the claimant's statement. The page numbers are at the beginning of my opening skeleton.
Right.
So that's the reason for giving those references there. On page 2 of my opening skeleton,
Oh, I see. Yes, I have seen these.
I've given
So
you
they're
the...
referred to all. And that's true for all the witness statements from now
Correct.
on, is it? Excellent. Well, that answers that question. Thank you. So the next question concerns Section E of the trial bundle. The documents are all in chronological order, but it doesn't seem to include all the documents in the witness statements, but presumably all the documents referred to in the witness statements are somewhere in the bundle, as we can see from that. All right. Now, I'm confused as to the difference between Section E and Section F. What's the difference? Why are some documents in Section F and some in Section E? Do we know? And in Section F, they don't always seem to be in chronological order, whereas in Section E, they are.
It's been the bane of my life over the last few weeks. I can't answer that. I think my little friend might be able to assist us.
Mr. Big Smith?
The short answer to this has been the bane of... Is this on? Is this on?
Red is on, curiously.
It's been the bane of my existence as
Yes.
well. The short answer is that those instructing me are very adept at this document uploading, but the system kept rejecting things effectively. And so what has happened is, and I think in fairness this is noted in the index when you get to the header of the relevant sections, what it says is that these are documents that for whatever reason, and the funny thing is some of them aren't actually that big in terms of pages, but they just didn't upload. So that's why they're there. And then there is, I should mention, there is another section called Other Documents, which are just things that are
Section I.
Section I, exactly.
Which I was going to ask the same question about that.
And Section I is, as I understand it, Section I is the same issue, and the advantage of the marked up witness statements is that the claimant is marked up in manuscript, the defendant is marked up electronically, is they do contain the correct documents.
Excellent. Well, I think that's fine. That solves my problem, because provided I've got the witness statements with the documents marked up, and provided I have a chronology with the documents relevant to each event by reference to page number in the trial bundle, and of course you will use the trial bundle page numbers in your written closings, then that's fine. That's all I will need. So thank you for that. That's very helpful. The last matter concerns the list of issues. Obviously the list of issues is helpful. As has been pointed out, that was prepared a year ago, and since then pleadings have been amended, so it's not cast in stone. And I should warn you, gentlemen, I reserve the right to not necessarily decide all of the issues in the form in which they've been expressed. So it may be, for example, that some of the issues fall away, and there are others that, just to take one example that jumps to mind, one of the list of issues seems to invite me to determine what the answer to the, quotes, Sharia conflict of interest issue is. Now, I don't presently see that I need to do that to resolve this case. Obviously, there were different points of view in relation to the Sharia conflict of interest. What I need to assess is the way in which those different points of view are expressed and dealt with in order to ascertain whether there was any breach of the relevant legislation in relation to that progress. I don't think I need... I mean, we all know that the matter was resolved a particular way, it was addressed, and eventually the arrangements were changed. So I don't know that necessarily I need to express any view on who was right and who was wrong. Rather, it's a question of the way in which the matter was dealt with, and in particular whether it sustains any allegation of unlawful behaviour on the part of the defendant. And there are probably other examples of that. So that, in other words, I'm not sitting as a kind of court of judicial review in relation to the way in which group Islamic banking was conducted within the bank over the course of 3 years. What I'm looking to do is identify whether the alleged unlawful behaviour took place, and that I think they are different things. So I hope that makes my position clear in relation to that. Those are the only points I wish to raise. Is there anything arising from that, Mr. Setti?
On the last point, I entirely agree. Your Honour, it's our position too. It's one of the reasons why I say some of the matters are background relevance. There are some relevance factually, but
Yes.
not for legal determination. In terms of the chronology, the first matter you raised, Your Honour, you're expecting that with our closing written submissions?
Yes.
Not any earlier?
Not any earlier. No. And I expect the burden of the work will fall on those who sit beside and behind you, Mr. Setti. So, hopefully. So,
The one practical point I have arising from that is obviously with the timetables of at the moment for written closing, if we're doing chronology as well, it may be that that moves back slightly, but I don't think that that...
I'll be in your hands. I think you'll find that just as it will be an aid for me, it will be an aid for you as well.
There's no doubt about that.
Yes.
The only point I would say on this point about not determining things, I should say that things are in issue on the list of issues primarily if there's a dispute on the pleading.
Yeah.
And I think that the point about this is Your Honour can take a view of relevance about this. But I do want to say that one of the questions that is going to arise practically for me when I'm cross-examining is that I'll wait to see what case my learned friend puts, of course. But one of the things is that a lot of the defendant's witnesses have, very much gone out to say, well, we were right on this issue. To take your Honour's example.
Well, I'm just not sure that'll help me. Yes, testing whether they were right or not is not going to help me. I don't think. And unless it goes to show. Unless the conviction with which they express that view reinforces your case.
Yeah, I agree, but I should just say I'll be trying to avoid, a micro-challenge about that, if that makes sense.
Thank you. Well, if there's anything else, we can move into the evidence.
We can, Your Honour, thank you.
All right. Mr. Bickford-Smith, would you like to call your witness?
I'd like to call Mr. Marmon, please.
Come forward, please, Mr. Mahmood. I should take a position over there. Yes, you stand for the moment, if you could.
Could you state your name and residential address for the court, please?
Shiraz Mahmood, apartment 3001, Tower 8. The residence is downtown Dubai. I swear by Almighty God to tell the truth, the truth, and nothing but the truth.
Thank you. Please have a seat, Mr. Mahmood. Mr. Bickford-Smith.
Mahmood, have you got page 7410 in front of you?
Yes, I did.
This is your witness statement, correct?
Correct.
Your first witness statement. I understand you have a correction to the name of an employer, is that correct?
Yes. I don't believe it's in this witness statement, but in one of my witness statements, I don't know if it's this one or the second one. I believe it might be the second one at paragraph 6. There's a correction I'd like to make to that.
Okay, well, shall we go then straight to that? Second witness statement is at 7822. Have you found that?
Yes.
What is the correction you would like to make to this?
You'll have to forgive me, Judge, but there's a document, and it's paragraph 6, and it's not on either of these witness statements where it's referred to me being employed by the Financial Conduct Authority as a senior policy advisor. It should be the Financial Services Authority, but it is paragraph 6 of one of the statements. But when I go to paragraph 6 of both these statements, it's not there. So,
and paragraph, so your evidence is that the correct name of the authority.
yes.
And then paragraph 6.28 of the document we're looking at, 7835. 7835.
Just going down to it now.
Do you wonder if it would be helpful to have a physical witness bundle? No one has a spare. Okay.
Which particular paragraph do you want the witness to go to?
6.28.
Thank you.
I understand there's a correction you had to this.
Yes, 6.28. I make reference to 2018-2019, and I can't remember. I'm not clear on the years on reflection, so just want to highlight that.
Subject to those points, can we just go to my apologies. Can we go back 7459? That's the final page of your first witness statement.
Yes.
Is that your signature?
Yes.
Is this your
Sorry.
Is this your truthful evidence?
It is. There is one other addition that I would like to highlight, please. And it's at paragraph 40, and it makes reference to, and I can't remember if it's the first or second sentence, so please forgive me, sir. It makes reference to my disclosure, to my 365 feedback in relation to Mr. Sheikh. That's a typo. It should be Mr. Akbar.
Well, there's no paragraph 40 in the second statement, so it must be in the first. Can you find that, Mr. Smith?
No, it's not at paragraph 40.
40A.
There's no paragraph 40A in this. I think that what you're probably referring to, I suspect. Wait a moment. Where's my pleadings file?
Maybe it's the pleadings.
Can someone help me? Is there a pleadings file? Volume 1. Here we go. Sorry. Yes, it's page 31. If you click on 31. And your point is, your correction is that this should say Mr. Akbar, correct?
It should say Mr. Akbar at 40A instead of Mr. Sheikh. And I believe this document hopefully also includes paragraph 6 that I referenced earlier.
Yes. Let me just put that in. It probably does. Let's get that right. Paragraph 6, page 11.
So what should that read instead of Financial Conduct Authority? It should be
Financial Services Authority.
Yes.
As a precursor.
Yes. Thank you.
Subject to those corrections, your first and second statements, those are your signatures, correct?
Correct.
And are they your truthful evidence?
They are.
Thank you.
Thank you, Mr. Bickford-Smith. Thank Mr. Mahmood. I expect Mr. Sethi will have some questions for you. Mr. Sethi.
Mr. Mahmood, I will seek to try and take things in as chronological a fashion as I can, so we're all very clear as to where we are in the story. Clearly this is going to take be a lengthy cross-examination that I have of you. If at any time you don't understand the question, please say so, otherwise I'll assume that you do. And if you don't, if you want to be taken to a document, let me know. Okay.
The other thing I'd add, this is not trial by ordeal, Mr. Mahmood. If you feel tired and need a break, just say so and we'll have a break.
Thank you, sir.
But otherwise, and if you don't need a break, we'll go through till 1 o'clock now.
That's right.
Let me just deal with some matters of background, employment history at the bank, with the individuals with which we will be concerned. Mr. Rehan Sheikh was already in position as head of the Group Islamic Banking Business Unit by the time you joined the bank. That's right, isn't it?
That's correct.
he reported to Mr. Koshal,
As far as I know, yes, I believe that to be correct. Yes, he did.
who was the bank's regional CEO for the AME region, that's the Africa Middle East region.
That's correct.
And Mr. Koshal was also chairman of the, Mr. Sheikh was also chairman of the GIB, the Global Islamic Banking Management Committee. Sorry, Mr. Koshal.
Yes, he was. Mr. Kosher was.
Excellent. So we have those two individuals already well in place in the bank before your arrival. Mr. Long, who was to be your line manager throughout your employment with the bank, was already in place as well, wasn't he, by the time you arrived?
He wasn't my line manager throughout my employment. Initially, there was Mr. Patel during my time at Financial Markets.
And you commenced employment with the bank on or around 3rd of August 2016. That's right, isn't it?
August 2016.
I don't think the precise day matters, but August 2016. And you joined as a senior compliance officer, Financial Markets, AME.
Correct.
Initially on a temporary employment contract for 6 months?
That's right.
Now, Mr. Vaselli, Alessandro Vaselli, was already in position as well, wasn't he, as head of legal
That's
for
correct.
GIB? And is there a phrase for GIB which, can, rather than saying those 3 letters every time, GIB or GIB, or was that never used at the bank?
We all used to use GIB.
GIB. Before you were appointed, there was a separation of the legal and compliance functions into 2 distinct functions. That's right, isn't it?
It preceded, I don't know if it preceded my joining the bank, but it certainly preceded my joining Islamic banking, and I was told that that happened, but I wasn't privy to it or why it happened.
Yes. I know that, just focus on the question, then it might be easy, but thank you. Now, it became necessary, Mr. Long will say, to create a compliance function, and that compliance function, new title, role, was then created. Now, a role, the new position, which you came eventually to occupy, was head of compliance for global Islamic banking, yes?
No, that's not correct.
What do you call the job title?
As per my employment contract, the role was Global Head of Compliance Islamic Banking.
Okay, global head of compliance for Islamic banking. Perhaps where we mean the same thing. Now, despite that title given to the new role, it was a Band 4 role, wasn't it?
Yes.
That role was not equivalent to a group head role within the bank.
I disagree.
Okay. Group head roles are Band 3 roles, aren't they?
Band 3 and Band 2, yes.
Not Band 4.
No.
So do you accept that this role that you came to occupy was not equivalent to a group head role within the bank?
No, I do not accept that.
Now, Mr. Long, your line manager, subsequent line manager, will give evidence in relation to what this means. He says your Band 4 ranking or status reflected a number of things. It reflected the fact, and I just want to see whether you agree with this, your role was limited to a small number of Islamic banking markets, wasn't it?
That's not an entirely accurate characterisation.
Well, if there's some other characterisation, we may hear in re-examination. But the second point is this. The GIB business unit operated a leverage model, didn't it?
It did.
And what that means, and that meant that most compliance risks were managed by business and country compliance teams, with the support and assistance being provided by GIB compliance on Sharia compliance where necessary. Do you agree?
That was the presumption of the model, correct?
Thirdly, your new role then reported to Mr. Long, who was a Band 3.
That's correct.
Fourthly, your new role did not sit on the group compliance management team.
No, it did not.
Now, for various reasons we don't need to go in at the moment, it was Mr. Long's opinion that your role probably merited a Band 5, but I don't need to trouble you with that at this stage. Now, at the time approval for the new GIB compliance role was granted in 2017, you were working for the defendant as a compliance officer for financial markets, yes?
No, as you said earlier, senior compliance officer.
Senior compliance officer for financial markets in the AME region. And we've seen your employment contract, which is dated the 1st of August 2016 in the bundle. That position that you occupied when you joined the bank was a Band 5 position, wasn't it?
Yes, it was.
So we're clear, when you join the bank, you're in a Band 5 role from...
Correction, Ms. Setti.
Yes.
If I may, please.
Yes.
So when I joined, I don't believe I was on a band, as far as I can recall. I was on a temporary contract. I don't believe temporary employees are banded. And it was after I was promoted to become a director of compliance that I was given a Band 5.
In that role, your first role, you reported to Zunaid Patel, didn't you?
That's correct.
And his title at the time was Head of Compliance for FM, Financial Markets. Yes?
I believe it was Head of FM Compliance AME.
Thank you. It's the same thing, but that's welcome clarification. But that role was a Band 4 role, wasn't it? So you were reporting to a Band 4 person in Zunaid Patel.
I believe it was.
Thank you.
I can't say with certainty, but I believe it was.
Sure, we'll hear from the defendant witnesses who know perhaps more intimately about these matters. And for the court's benefit, Zunaid Patel is somebody who figures at the beginning of the story and at the end, because he's the person that is successful in the final new role following the redundancy situation. You were interviewed by Mr. Long, weren't you, for the role that you took on, the new role, that is, of Global Head of Compliance for GIB.
Mr. Log was one of the people that interviewed me, yes, for the GIB role.
And so from the outset he was quite familiar with at least your information relating to your skills and qualifications and experience in applying for that role.
I would say he was more than familiar. He interviewed me for when I originally joined the bank in 2016 as well.
Good. Now, he will say that you did not have senior or broad experience of FM compliance, either at the time you joined the FM team in September 2016, or when you moved into your new role in July 2017. Would you agree?
That's his opinion. I would not agree with it.
Okay. And as you say, somebody who knows your skills, experience and qualifications more than well. Now, you commenced your role then as Head of Compliance for GIB, or Global Head of Compliance for GIB, in July of 2017. And we see your employment contract in the bundle at page 1011. That's just for the court's reference. I don't need to take you to that. There are no real contractual disputes as such at present. But can I take you to your job description, dated the 6th of December 2017? That's at page 1101. You agree this is the job description you were working to?
This was the job description I was made to sign upon taking up the role.
You use the phraseology of made to sign.
I do.
Did you sign this under duress?
I was not content that I was a band 4 for a global role when all my peers were a band 3. I expressed that discontent in a cordial manner to Mr. Long, with whom I had a cordial relationship. He said, look, you need to sign the job description. I will take it up in Singapore, and on that basis I signed the document.
It says, so what you say is that you didn't feel that your job should be graded at band 4. You identified that matter with your line manager, Mr. Long, but nothing changed in relation to that, did it?
Well, to be fair, sir, I didn't say I felt it. I just thought in a very objective manner, as a global head of a global business, all other global business compliance heads were band 3. And so it wasn't a question of me feeling that I was the wrong grade. I just looked at the objective evidence that was before me. And
I wasn't intending to be pejorative in any sense. I was just trying to cut to the chase, really. But I want to see what your objection to the job description is. Your objection to the job description was the banding category, the grading category, as we see at the top of the page, grade 4, not with the substance of it.
I beg your pardon?
This was, can we just, I didn't think this would be controversial.
No.
This was your job description, wasn't it, for your role?
It was.
And this job description never changed, did it? I know it's generic, but it didn't change during the currency of your employment.
As far as I recall, no, it didn't.
Okay, good. So let's have a look at it. These set out your responsibilities, and they include a number of matters that we agree were your responsibilities. Under the first bullet point, it says, help the group meet its commitment of being here for good by building a sustainable compliance framework that places regulatory and compliance best practice standards and a culture of appropriate conduct at the forefront of the group's agenda. And when it's referring to group here, it's referring to the GIB, isn't it? Business unit.
No, it's referring to the SCB group. So the group had an agenda, the wider Standard Chartered Banking Group.
Okay. And then, if I can take you to the bottom bullet point on page 1101, it says, maintain constructive and effective relationships with business heads, business chief operating officers, and be the interface between compliance heads and the Islamic Banking CEO and Islamic Banking Management Committee. Do you see that as a primary duty or responsibility in your job description?
I saw it as one of all the responsibilities.
Yes, one of a number.
Yeah.
But it's expressly set out in a bullet point there on the first page. Can I take you to, and I raise these because these are matters obviously that will become relevant in due course. Over the page on 1102, under the heading of business, the first bullet point here speaks of build and maintain an effective and constructive relationship with all key business and functional stakeholders that is based on trust, capability and integrity, providing timely, responsive and quality regulatory compliance advice and guidance to enable the business and functions to achieve their strategic, tactical objectives. Yeah? You agree that was a fundamental part of your job description?
I wouldn't say any one of the things you're reading out is more fundamental than any other.
Are they? Would you accept that they're all equally fundamental?
They're all key components of the job.
Thank you. If you move down to 2, 3, 4, fifth bullet point under business. You are expected to formulate and implement the compliance leveraged model to support SADC. And SADC, as court will know, is a reference to the Group Islamic Banking Business Unit. Yes?
That's correct.
At bottom of the page, under people and talent, you are expected to lead through example and build the appropriate culture and values, work in collaboration with risk and control partners. See that?
I do see that.
And if you move on a page but one, which is page 1104, it's quite a it's a sufficiently detailed job description, isn't it? Than we often find in employment. Top of page 1104, under the heading of regulatory and business conduct, display exemplary conduct and live by the group's values and code of conduct. So you start in July 2017 in this role. You report directly to Mr. Long. And from July 2017 through to January of 2021, that was your reporting line, wasn't it?
To Mr. Long?
Yes. So he's your line manager. Often they're the individuals who know their subordinates who report to them and are their direct reports well. And you say he was more than familiar with your qualities, skills, experience, qualifications. And we now see that during your entire time, you reported to him. Yes?
Yes.
Now, I spoke about the leverage model earlier, which is referred to in the job description. Whilst you obviously had responsibility for overseeing compliance matters for GIB, you were not solely responsible for doing so, were you?
I was for GIB.
Well, your role was not equivalent, as we've established, to a Band 3 group head role within the bank, certainly not classified as such. And you reported to a band, to Mr. Long.
Your Honour, can I just ask a question, please?
Well, yeah, what question would you like to ask?
It's just a procedural one, because Mr. Sessi just said we've established something, and I don't believe we have established. Do I go back to him?
Well, Mr. Setti, perhaps if you just ask
Just ask the question.
Sorry. Yes. Sorry.
Would you like to repeat the question, Mr. Setti?
You were not solely responsible for overseeing compliance matters within GIB. Let me tell you why I say that before you answer because I think you wanted to disagree. You reported to a Band 3 in Mr. Long, who was regional head of compliance for CCIB in the AME region, yes? And Mr. Long reported to Christopher O'Donnell, who at the time had responsibility for regions compliance for CCIB. And in addition to his role as head of compliance for the Americas, with a matrix reporting to Emmanuel de Groot, who was a regional head of compliance for the AME region. So it's fact, isn't it, that you all shared responsibility for overseeing GIB from a compliance perspective?
Not at all.
I see. Well, you clearly differ to the views of Mr. Young, O'Donnell, Mr. de Groot, and others, but we can agree to disagree. Now, just want to deal with the SADC business. When I said earlier, and I think you agreed, that I think you didn't quite agree, actually, to be fair to you, when I said the role was limited to a small number of Islamic banking markets. Let me tell you what I mean by that and see if we can agree on this. The GIB business is called SADC, isn't it, which is Arabic for truthful.
It is.
And what it covers geographically is the Asia region, in particular Bangladesh, Malaysia and Pakistan.
Are you talking about the totality, or?
I'm dealing with the geographical scope of the Islamic banking markets with which you were dealing.
That was global in nature.
So Bangladesh, Malaysia, Pakistan, and Bahrain and the UAE in the AME region. So it was just Bahrain and the UAE, wasn't it?
No, there were more.
And the global hub for GIB in the bank is based in the UAE, isn't it?
That's correct.
And it's the only group, the only business unit in the bank which is based outside of Singapore.
As far as I'm aware, yes.
Now, all of the bank's Sharia services, all of the bank Sharia products, Sharia transactions, are supervised by an independent Sharia supervisory committee, the SSC. That's right, isn't it?
Yes.
And the SSC consists of globally renowned, respected scholars on Islamic banking and finance, correct?
That's correct.
They're not employees of the bank, are they?
I can't comment definitively on the employment relation between them and the bank.
You see that they serve as independent Sharia advisors to various international banks and financial institutions. That's right, isn't it? They're external to the bank.
They are not employees as such, but they have some form of relationship. I don't know if it's an employment relationship. I've not been privy to their contracts.
Their responsibility is to ensure that any proposed SADC product or transaction is Sharia compliant, correct?
That's correct.
And if a product or transaction doesn't comply with Sharia principles, the SSC won't allow, they will not allow it to be offered under the bank's Islamic banking framework.
That's correct.
So the SSC's approval process serves, doesn't it, as an independent verification that the proposed product or transaction that's being offered by the bank under the Sharia, under its SADC offering is Sharia compliant.
In theory, you're right. In theory.
Okay. Now, when you worked at the bank, Mr. Sunil Kaushal, the bank's regional chief executive officer for the AME region, he was chairman of the GIB management committee we established a moment ago. We did establish that.
We did.
And we established that Mr. Sheikh became head of GIB before you'd arrived. In fact, it was in 2015, some years, a couple of years before you took on your latter role. The other individuals with which we'll be concerned were the following, weren't they? There was Arsan Ali, who was head of client international business and client business.
There was Mr. Ali.
I'm just dealing with members of GIB at the moment.
Yes.
Kuram Hilal, who was head of products within GIB. Mohammed Mubin, who was head of Sharia. Sahel Akbar, who we'll no doubt hear a lot about, was COO, Chief Operating Officer. Ali Alawala was the CEO of SADC Malaysia.
He was global head of retail when I joined. He went for a stint in SADC Malaysia, I can't recall how long, and then he came back as global head of retail.
And Azhar Aslam was head of Islamic banking, Pakistan.
Yes, he was, but he wasn't part of GIB per se.
And just so we're clear, all of those people were reported to Mr. Sheikh as the CEO of GIB.
Yeah, you missed out Sahami.
Sahel Akbar?
Sahami.
Sahami. They were all based in the UAE as well, weren't they?
No, Mr. Aslam was based in Pakistan.
Sorry, apart from Mr. Aslam. Beg your pardon, thank you. Mr. Alessandro Vaselli, who was head of legal for GIB, did not report to Mr. Sheikh. That's right, isn't it? He reported into the legal function.
That's correct.
Now, we mentioned the head of Sharia. Mr. Mubin. he provided daily guidance on compliance with Sharia, didn't he? To the GIB business unit.
As far as I know, yes, he did, I believe. That was one of his functions.
Now, the bank's Sharia department performs assurance responsibilities, doesn't it?
When you say assurance...
Let me explain what I mean by that. It does not have the power to give approval for any SADC services, products or transactions, because that goes to the SSC. Yes?
There were some limited delegated powers that the Sharia Committee had given to the Sharia function. I don't know the full scope and breadth of those. I don't believe that it delegated full approval authority, but some powers were delegated to the Sharia.
Well, there may have been some powers, but in the main, it undertook assurance, not approval responsibilities.
That's not correct.
Any SADC service or product proposed by the products team would have to be reviewed and approved by the SSC, correct?
Before release to the public, yes.
Yeah. And only once SSC, the external independent body, has issued its approval, can a specific service or product be offered to the bank's customers under this SADC framework. Correct?
Once it has been certified as Sharia compliant, then it can be offered to the public.
By the SSC.
Certified by a Sharia board, yes, an external Sharia board.
Yes. You understood, didn't you, that in other jurisdictions where the bank offers Islamic banking services, like in Pakistan, there are local regulations there which require the head of Sharia to report to the compliance function.
That's correct.
But there was no such regulation applicable to GIB and the DIFC. That's right, isn't it?
That's correct.
I believe you made reference to a standard, the UAE Central Bank issuing a standard regarding Sharia governance for Islamic financial institutions in April of 2020. You understand, don't you, that that standard came into force in May of 2020 with the deadline for compliance being May 2021. Did you understand that?
Are you talking about me? Are you quoting me specifically? Or?
Are you aware of the UAE Central Bank issuing a standard on Sharia governance?
I'm aware that a draft of that was issued.
Yeah.
Through my team.
And the defendant's evidence will be that the standard, the deadline for compliance of that was not until May of 2021, after the termination of your employment. Do you agree?
I can't recall the specific date and whether it was after my termination.
Okay, we can't recall.
If it's got a date from the central bank, I'll take that date from the central bank.
Okay. And it even came into force after your... sorry, the other point is this, that the standard does not apply, even now, does not apply to Islamic financial institutions in the DIFC.
That's correct.
Let me just deal with the GIB compliance function. And this is to make sure we have all a very clear and agreed understanding of what is meant by the leverage model. GIB operates under a leverage model. We did establish that a few moments ago. And what that means is that the business leverages off the bank's conventional business infrastructure to provide their products and services. Correct?
That's correct. It leverages off the conventional infrastructure.
And under this so-called leverage model, responsibility for the distribution of GIB products rests with the conventional business that sells the products to the bank's customers. Yes?
Not just the business.
The responsibility extends to the support functions aligned to those businesses that sell the product to customers as risk owners, including compliance.
I don't know about risk owners, but certainly at a country level, the local compliance legal operations teams were responsible for ensuring delivery of that product was in line with local regulations.
Yes. Now, under this leverage model, Islamic banking and Sharia compliance risks are managed by business and country compliance teams, yes?
No.
With support and assistance being given by GIB compliance where necessary. Do you agree?
It's difficult in terms of the wording, the way you put it.
Really?
Yeah.
What is it? I'll let you explain.
So I would say, it would be impossible for the countries to manage that Sharia risk because they just did not have the knowledge. Compliance officers sitting in Singapore or Hong Kong hasn't got the first idea about Sharia compliance. They've never dealt with that. So to say they were managing it is not really accurate. That was more managed at a GIB level.
Well, yes, I mean, the point is it's managed by the business, supported by control functions such as compliance and legal. So let me give you an example, or put it in other words. Your role, Mr. Mahmood, was to provide support to business and country compliance teams. Yes?
It was the same as all global heads, yes.
Well, just answer the question. Your role was to provide support to business and country compliance teams.
Amongst other things, yes.
Thank you. You were not responsible for all compliance matters relating to all the Islamic banking products and services provided by the bank.
From a Sharia perspective, I was. Sharia compliance perspective. But at a country level, no, I was not.
Well, I put the question to you. We hear your opinion. Let me move to the issue of the Sharia reporting line. A matter which arises and doesn't really go away for a long time. Even before you had started your role as head of compliance at GIB, Mr. Long asked you to review a draft governance paper for GIB, didn't he?
He did.
And to provide your feedback.
That's correct.
And as we know, in your feedback, you identified a potential conflict of interest in the head of Sharia, Mr. Mobeen, who we heard about a few moments ago, reporting into the head of GIB, Mr. Sheikh.
I can't recall if it was expressly stated in my written feedback, but I certainly spoke to Mr. Long and said that there was a conflict of interest. I was sensitive that I was being put forward for the Islamic banking role, so I didn't want to upset the CEO and kind of criticise an existing structure before even joining the function.
Now the bank will say that its approach to potential conflicts of interest reflects the principles of MiFID II. You're familiar with MiFID II, are you?
To a degree.
And that emphasises the importance of assessing and managing potential conflicts of interest by reference to the likelihood of the conflict being realised, and if it was realised, the likely resulting impact. Do you agree?
That's fair.
And depending on the outcome of that assessment, the bank could impose directive controls, preventative controls, or detective controls. You're familiar with those terms?
I've heard those terms. I'll take your word for it.
Well, just for the court's benefit, directive controls, those that aim to establish desired outcomes. Preventative controls, to prevent undesirable events from occurring. Or detective controls, designed to detect and correct undesirable events which have already occurred from reoccurring. Good. Now, the bank recognised that having the head of Sharia reporting into the head of GIB was a potential conflict of interest. Do you agree?
I'm not comfortable with that wording.
Right. Well, we'll get drawn into a lot of the detail about this very shortly. But just standing back from all of this, do you accept the proposition that your employer, at a certain point in time, accepted that the so-called Sharia reporting line issue was a potential conflict of interest? Do you accept that proposition?
At a certain point in time, they recognised it as a potential and an actual conflict of interest.
and you accept that your own line manager, Mr. Long, did not consider it to be an actual, realised conflict of interest that could not be managed.
I disagree with that characterisation based on some of the conversations I had with Mr. Long.
Well, your counsel will have an opportunity to challenge Mr. Long on this matter. We shall wait to hear what transpires. But do you accept that there is no written reference, no document in the 8,000-page bundle that we have in front of us, which says anything other than Mr. Long's belief being that it did not amount to an actual conflict?
I don't believe Mr. Long, I can't recall having seen anything, but that would be very uncharacteristic of Mr. Long committing that kind of thing on paper.
Now, your own line manager did not consider the Sharia reporting line to be a significant issue or particularly impactful from a risk perspective. Do you agree?
I would very strongly disagree with that.
Let me see if we can establish three things. Firstly, the reporting line did not constitute a breach of any applicable law or regulation in the DIFC. That's right, isn't it?
It did.
The structure of GIB had been approved by the DFSA, the Dubai Financial Services Authority, in 2010 when the licence was obtained.
That's correct.
I believe we have the organisation descriptions that were submitted as part of that authorisation to practice licence by the DFSA at page 850 in the bundle. Go to that. And we see there, don't we, that if you look at the third level or row of names or boxes, we see that head of Sharia department there, Mr. Mubin, reports up to the CEO, SCB Islamic Banking.
I can see that.
Secondly, you accept, don't you, that there were rigorous controls in place in the form of the requirement for all Sharia services, products, transactions to be the subject of independent SSE approval?
No, I don't accept that.
You don't consider the independent SSE to be a rigorous approval body?
Not the global one, and many, not just for SCB, but it's an industry-wide problem. Many Sharia boards are not as rigorous as they should be.
Well, let me put it this way. You accept at least that it would be extremely difficult for the head of Sharia and the head of GIB to push through a Sharia service or product or transaction, whatever it might be, which didn't comply with Sharia principles. Your view, your opinion on this is in marked contrast to that of more senior members of compliance, but we'll come on to that later. Less observation and comment by me, I'm sorry. Thirdly, you accept, don't you, that GIB was subject to regular group internal audits?
I can't comment.
Can't comment.
I don't recall. Not during my time. Maybe there was one. I don't know.
Now, the approach of your managers to conflicts of interest is and was that if potential conflicts are identified, if they are discussed, if they are recorded, they can be managed to stop actual conflicts occurring. And Mr. Long says that he took the view that the Sharia reporting line issue was a potential conflict which was manageable, and it posed, as I said earlier, relatively little risk to the bank. Now, is that an opinion of your line manager in compliance that he was entitled to hold, in your view?
Well, firstly, I'd like to say that that's not what he said to me.
Is that an opinion that your line manager in the bank would be entitled to hold?
Not in the face of the evidence, no.
Are you telling this court that when Mr. Long gives that evidence, he will be lying to this court, that that was his view?
I can't speak to Mr. Long's veracity on a future event. I don't think that's...
Well, hold on. You just said words to the effect of, well, that's not what he said to me at the time.
Yeah.
So are you saying when he tells the court that that was his view at the
I have
time,
no idea what
he
he's
would
going
be...
to tell the court.
Well, let me tell you... Well, you do, actually. You have read his witness statement, haven't you?
It's been a while.
Let me tell you now, he is going to say that. And if he says that, is your position that that's a barefaced lie?
My position is that when I spoke to Mr. Long...
No. First answer my question. Is your position, if he gives that evidence, that he did not actually hold that belief at the time?
I do not believe that Mr. Long had that view consistently throughout my experience with him. He knew there was a conflict, particularly in the face of staff complaining about being pressured.
Now, let's move on to the framework, the draft compliance framework. It was shortly after you started in your role in June of 2017. And Judge, I'm conscious of the time. I'm moving on to the draft framework.
Would this be a convenient time to break?
I think so.
All right. Let's adjourn until 2 p.m. Mr. Mahmood, this will apply to all the adjournments that we take during the course of your cross-examination. You are not to speak to anybody about the evidence that you've given in the course of cross-examination. That includes especially your lawyers. So unfortunately, between now and whenever your cross-examination ceases, you are to have no contact with your legal team in relation to these issues. So during the lunch break, just go and get yourself some food, wander about, be back a few minutes before 2 o'clock, ready to resume, and don't talk to anybody in the meantime.
I'm not allowed to talk to anyone.
Not allowed to talk to anyone.
I can order some food.
You can order some food, but you're not allowed to talk about any of the evidence that you've
Yes,
given.
sir.
And that will apply, when we adjourn tonight, that will apply overnight. It will apply until Mr. Setti finishes asking you questions.
Understood, sir.
Right, thank you. We'll adjourn until 2 p.m.
All rise.